Once two people have decided to negotiate through the collaborative law process, they are provided with information about what will happen, what they are required to do, and how they're required to act. I'll talk about how each participant is required to act in another short video, but here what I'm going to talk about is what actually happens at that first meeting. In preparation for the first meeting, two documents are prepared. They are the contract and a draft agenda. In another short video, I'll talk about the contract and the expectations and obligations it places upon the participants and their lawyers. The first meeting is not just about breaking the ice, introductions and meeting all the participants to the collaboration, but also about identifying what urgent and important issues need to be talked about and what are the hopes, fears, concerns, goals and needs of each of the participants. This forms two parts of the meeting. The first part being a discussion about the contract and also in relation to urgent and important issues, and the second part about the parties' aspirational goals. The first meeting is not just about breaking the ice, introductions and meeting all the participants to the collaboration, but also a discussion about the contract and each of the participants' hopes, concerns, interests, needs and any fears. The agenda therefore has a number of topic headings: urgent and pressing issues, principles of collaboration, signing the contract, and a roadmap towards an agreement, setting out what it is we need to do in order to get to that final place. Any meeting should take no longer than 2 hours. It is up to the lawyers to ensure that the time is spent as constructively and as positively as possible. One of the agenda items is to discuss with each of the participants what they want the agreement to do, to address and to acknowledge. This is vital. Though the parties at this stage can feel that these conversations are a little airy-fairy, for want of a better phrase, from experience, the amount of time that is spent at this important point is invested for a long-term benefit. That is, at a certain time during the negotiations, maybe at the third or fourth meeting, when we're comparing the various options and weighing and balancing which may be preferred to the other, we always go back to the set of goals that we had articulated and discussed at that first meeting to find a benchmark as to which option may be the best option going forward, and to address all of those goals, concerns, fears and needs that each of the participants had addressed and had articulated at that first meeting. Someone may ask, and some critics of collaboration will say, isn't it a waste of time talking about some of these bigger aspirational goals? Why can't we just get down and talk about the nuts and bolts about who wants what? What I say in response is, how do you know that the deal is a good deal unless you've got some framework to compare it against, to actually see whether what it is that you've agreed to addresses the things you outlined right at the beginning you need the agreement to do? Unless you've had that thought process, you really don't know whether the agreement is a good one. And agreeing for agreeing's sake isn't a good outcome, because from experience, the stickability of those sorts of agreements, when one party may not own the outcome, is not a good agreement and can fall over or be revisited sometime in the future. Investing a little bit of time at the beginning of collaboration can reap great rewards further on down the track.